President Trump is taking his fight over birthright citizenship straight to the Supreme Court. This comes after he has lost repeatedly in lower courts and appellate courts across the country. Now, as I've reported, on President Trump's first day in office, he signed an executive order that would end the right for a baby with non-citizen parents born in the United States from automatically receiving American citizenship. Since Trump signed that order, judges across the country have blocked him, ordering nationwide preliminary injunctions that have stopped him and the United States government from implementing that order or even working on plans to implement that order. These judges have called this order blatantly unconstitutional and have said the order contradicts more than 100 years of Supreme Court precedent. Now, the president, at least right now, is not asking the Supreme Court justices to weigh in on whether his order is constitutional or not. Right now, he is asking the Supreme Court to just lift those preliminary injunctions and allow his birthright citizenship policy to take effect while these cases continue to play out in lower courts. The Department of Justice filed this 43-page emergency petition on behalf of the president to the Supreme Court today, and in it, the Trump administration argues the judges who have issued these nationwide injunctions are overstepping their authority, saying federal judges should not have the power to issue nationwide injunctions against his administration, and that instead, those injunctions should be limited in scope to only the plaintiffs in the case, not the entire country. Quick note here. The fact is, Republican-led states used this exact same mechanism in the courts when President Biden was in office and enjoyed a lot of wins when federal judges issued nationwide injunctions blocking Biden's executive orders and actions. So this definitely goes both ways. Okay, back to this Trump petition to the Supreme Court. The petition also frames birthright citizenship as a national security issue, saying it has created strong incentives for illegal immigration and has led to birth tourism. Now, it's unclear whether the Supreme Court is even going to grant this emergency appeal from the Trump administration. They absolutely do not have to. And if they don't, that means the lower court's injunctions will stay in place and the Trump administration will remain blocked from moving forward. But the reality is, in the end, this case is absolutely going to come back to the Supreme Court, and they will likely have to decide whether this order is constitutional or not. Trump's order to end birthright citizenship says if you are born in this country to parents who are not here legally, or you are born to a mother whose presence was lawful but temporary and a father who is not here legally, you do not get U.S. citizenship. And if your state issues you some kind of government birth document and your parents fall into those categories, the federal government will not accept it. This policy, according to Trump's executive order, is not retroactive. That means it would only apply to any baby born within the United States after February 20th of 2025. Now, here's where the Constitution and that precedent comes into play. We have the 14th Amendment in this country, and Section 1 says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, that is the amendment. Those are the words that establish this birthright citizenship. And it's been around for more than 150 years. Obviously, no executive order from any president can overturn an amendment to the United States Constitution. But Trump's order is attempting to pick it apart by instead focusing on the phrase subject to the jurisdiction thereof. His executive order suggests that children of non-citizens who are born in this country are not subject to the jurisdiction of the United States and therefore are not covered under the 14th Amendment. More than 125 years ago, the Supreme Court ruled that the 14th Amendment does entitle a child to automatic citizenship, even if that child's parents are non-citizens. And then Congress codified that understanding in the Immigration and Nationality Act of 1952. But the Trump administration is now arguing in all of these courts across the country that that interpretation of the 14th Amendment by the Supreme Court 125 years ago and by Congress more than 70 years ago is wrong. They will ultimately want the United States Supreme Court to side with their interpretation of the 14th Amendment clause, making children of non-citizens ineligible for citizenship in the United States. Now, we are a long ways away from that happening or the Supreme Court hearing the merits of this case, but that is absolutely where this fight is headed.